Hey, good morning from the office. We're North Georgia's only live online morning show. We apologize for the delay. We had a software update that we had to make a correction on, and that happens from time to time. So yes, we very much apologize for the delay this morning, and I hope I can get in the groove of things. On Sam and Amanda been trying to work out some things for about 20 minutes to get us up and running. So hopefully we're putting the word out all over social media that we're working on this. But hey, let's get started. Let me try to get through this. I'm sorry for the delay again. And if you want to contact the show, 706-889-9700. And if you would like to send me an email, chief@fetchernews.com, chief@fetchernews.com. You can follow us on Twitter, @FetcherNews, @FYNTV. Subscribe to our YouTube channel, FYNTV Fetcher News. Okay, now yesterday, the Supreme Court, and it's interesting, I did this on purpose on social media, and social media has lit up, and conservatives have gone wild, and you are upset because it's being called a narrow decision, 7-2. And I put that on our Facebook page on purpose just to see who would send me a message, and I got a message. And I understand when you sent me a message that said, how do you call a 7-2 a narrow decision? Well, the media has done that on purpose. They don't want you to split it up. They didn't put a comma, but the decision is very narrow in the scope of what the justices made a decision on with Jack Phillips, the cake baker in Colorado. That decision is very narrow in scope, but 7-2 in the decision. So they've done that on purpose all over the place, a narrow decision. Now, I want to say something about what happened yesterday. For those that could get upset with me, okay, we do not want an activist court, okay? We do not want an activist court when it does not benefit us, but if it does benefit us, we want an activist court. Now, we need to understand something, and the only way I know how to put it is that way, is that constitutionally, the Supreme Court finds that is the decision-making on whether a law meets the constitutional standards. And once the Supreme Court rules, it's now a constitutional ruling, okay? Now, we got to understand that. Now, yesterday, see, here is an interesting thing. At least all of the activities that are taking place with Trump, the President of the United States, saying that he could pardon himself, that we're discussing whether he can be indicted, subpoenaed, all right, whatever. We're actually taking a little bit of time and looking at Congress, the executive branch, and the judicial branch. Congress makes law, not the President of the United States. President of the United States enacts that law by his signature, or it goes back and there's a veto override, whatever, gets technical. After that, it can be challenged in the courts. It can be taken all the way to the Supreme Court. But then once the Supreme Court hears it on its constitutional merits, now that's what the Supreme Court, I'm going to say only, all right? Now you got a lot of, I'm no legal scholar by no means, but the Supreme Court's really number one reason to be there is to define and look at a law on its constitutional merit, period. That's why former Supreme Court Justice, put him up, Antonin Scalia, okay? Antonin Scalia said he liked his Constitution dead. It was done. It was finished, okay? Former, now Antonin Scalia, which died about 2 years ago, Supreme Court Justice. Do we have the pictures in I was told we had all the pictures in. Okay. Former Antonin Scalia, okay, he liked his Constitution dead. He did not like it living and breathing, okay? So let me get back to where I'm at. The Constitution, the Supreme Court, is to determine the constitutionality of a law or a decision of a lower court. Is it constitutional? All right, so let's go there. Second, the Supreme Court has made abortion the law of the land. Wait a minute, that's not what we're talking about. Well, stay with me just a minute. The Supreme Court made abortion the law of the land. Now, whether you agree or disagree with the Supreme Court, fine. Okay? But it is law of the land. Now, the Supreme Court made gay marriage, okay, which has rights that go with it, marriage has rights that go with it, the law of the land. Agree or disagree, all right? Now, these are not apples for apples, but there's an example here. Okay, under President Obama, the Supreme Court made gay marriage the law of the land. Okay, now we're talking about a baker, okay, that rejected a couple, a gay couple that wanted to get married in 2012 before the Supreme Court said gay marriage is the law of the land. Okay? All that being said, no matter whether you like it this morning or not, in the United States of America, gay marriage is the law of the land. A gay couple, we watched Kim, I forget her name, up in Kentucky. I think she went to, did she go to jail or whatever, over not, a clerk of court over not issuing a marriage license to a gay couple. It's done. It's the law. All right? In America. Now, the reason I bring that up is Antonin Scalia, and this is a great book I recommend. It's a college course. It's not an easy read, especially for me, maybe for you. It's called Scalia's Court, The Legacy of Landmark Opinions and Dissents, Antonin Scalia. Now, the interesting thing I want to bring up this morning, in Scalia's Court, this book, there's a whole section on abortion. And I'm not going to bring up the whole thing, but there's the case there's the case that he breaks down, and here it is: Webster versus reproductive health in 1989. Okay, and here is a comment that the Chief Justice made. It thus appears that the mention of constitutionalized abortion law, there's this big mansion, it's called the abortion law. It thus appears that the mention of the constitutionalized abortion law constructed overnight in Roe v. Wade. Okay? Gay marriage constructed overnight. Boom. All right? Constructed overnight in Roe v. Wade must be dismantled door jam by door jam and never entirely brought down, no matter how wrong it might be. Now, what Justice Antonin Scalia was saying, and I want to talk about this decision yesterday because I keep hearing narrow, okay? So let's change narrow with a door jam, all right? A door jam. So I hear narrow decision 7-2, and they don't put a comma, but the reality is what they're talking about is the parameter of the decision is very narrowed and focused to the Colorado Equal Whatever Commission. We'll bring that up in a minute. But just like Antonin Scalia said, no matter how wrong abortion is, right or wrong, no matter how wrong it might be, it is a constitutionalized abortion. So you have constitutionalized now gay marriage, period. And he says Roe v. Wade must be dismantled, door jam by door jam, and never entirely brought down. Okay, on the decision yesterday, I just want to be clear with you. gay marriage, if that's what you wish to have overturned, will never be brought down. You will have to adjust it door jam by door jam, much like the references that Antonin Scalia made. And yesterday was one of those cases, all right? Now, yesterday, the decision was made 7-2. And Kennedy, Chief Justice Kennedy, put him up there, okay? Jack Phillips is a cake baker out in Colorado, all right? And he, let me get the, just a second. There, just a minute ago, I guess I lost place there. All right, but Jack Phillips is a cake baker out there in Colorado, and what has taken place, and it was a great piece here in the Colorado politics, because I wanted to go into Colorado. I didn't want to go into all the national media, and I wanted to go into Colorado because that's where it took place. What masterpiece ruling means for the Colorado Civil Rights Commission. All right. Now, everybody seems to be taking the part out of this that they want as a win. Put up just any picture of Jack. And Kennedy read the opinion yesterday. And here is Jack Phillips. But it's what happened is somebody walked in, and let me tell you what you think. Somebody walked in and he bakes cakes. All right. Now, there's a lot of ways to look at this. If somebody would have walked in and there was cakes on the shelf and they were priced. So if Jack took the price gun and he marked all the cakes equally or in a certain range, that all of these cakes here are $9 and all of these cakes are $10 and all these cakes are $12. Well, at the time he's pricing these cakes, he's not making a decision that this cake is $13 for the gay couple and this cake is $11 for my friends, and or Thursdays is 25% discount day to anybody but gay. And I'm being serious about the decision that was made yesterday. So he goes through and he prices all the cakes that he bakes on a daily basis and cookies. A dozen cookies is $9.99. All right. And anybody, he has a door that says it's open to the public, and he has a door and it's open and there's no discrimination there on his part, and they come in and no matter who it is, puts a dozen cookies or says, can I have that cake that's marked clearly in the window, $30. They put it on a counter and run it through the cash register. Fine, all right? I understand that. You understand that. Why cannot people understand that logic? Now, if you reach across and say, I would like to order something special, I do not want that cake and I do not want that cake, although they are priced the same for everybody no matter who walks through the door, whether it's a black customer, an Asian customer, Latino, gay, no matter what it may be, whoever it may be. But I want you to bake this cake and give me a special price, okay? Now, here's what I want to know, okay? Because I want to know if we were discriminating against customers in our construction business. All right? Because we always gave custom prices. There was never, in our kind of business, there was never, the job is $10,000. Every bid was different based on the square footage, the products you wanted to use, how you wanted to go about doing it. Whatever it may be, the pricing was different. So in my life, I have gone to a lot of houses and I've looked at the jobs where somebody called me, and I've looked at the jobs and gone back to a meeting and said, I don't think we should do the job. I'm just not comfortable with the customers. I'm not comfortable with the situation. Just don't like the vibe in the place. Whatever. I don't think we should do the job. Call the customer up and say, we're sorry, at this time, we're not able to fit your job into our schedule and will not be able to price your job. I don't know if I discriminated against somebody because of any reason whatsoever. I don't know. Is that discrimination? This guy decided he could not personally take his hands and build a specific cake, paint a cake a certain way, do things a certain way for this. Okay? Now, the U.S. Supreme Court decision in the case of Lakewood baker Jack Phillips of Masterpiece Cake Shop focused on the Colorado Civil Rights Commission, whose actions against Phillips over his refusal to make a wedding cake for a same-sex couple was overturned in the High Court. Now, that's what we have to be clear on, is what went before the High Court was the Colorado Civil Rights Commission decision. And this gay couple that actually, before gay marriage was legal, came into his shop, wanted a cake. He said he could not personally make a cake for their wedding. I mean, you could pick through what we have here, but I cannot personally make you a cake. Decided to go and file a complaint to the Colorado Civil Rights Commission. All right? So when they filed a complaint to the Civil Rights Commission, it went to the appeals court. Took it to the appeals court. The appeals court upheld the Colorado Civil Rights Commission. Took the appeals court to the Colorado Supreme Court. The Colorado Supreme Court chose not to hear the case, which meant the Colorado Appeals Court decision would stand. So Jack Phillips took this to the Supreme Court. Now, what was decided yesterday was the decision from the Colorado Civil Rights Commission. All right? That's why it was very narrow. That's why it was very, in a other way to put it, a door jam of a decision within the big scope of things. So a lot of people are upset that it did not go any further. It did not step out and protect other religious freedom, religious rights, religious liberties. You know, we are still supposed to be protected under the Constitution of the United States. We are still supposed to be protected, actually, by the national RFRA legislation. But a lot of people are upset that it didn't overstep. It didn't go further. It didn't go deeper in the decision. So you ask yourself this morning, would that have been an activist court? Now, if you, let's just say, as a Christian that maybe does not believe in same-sex marriage, okay, I'm not going to say the world ended there. It doesn't. You don't believe in same-sex marriage. You have a problem with the Obama Supreme Court that made same-sex marriage legal. Do you really want an activist court that is not going to take the cases before them on the merit of the case that's sitting in front of them? Just make sure you understand, you don't want an activist court either way. You want a court to rule on the merit of the case before them based on its constitutionality, which in this case is the decision of the Colorado Civil Rights Commission. The narrowly focused Supreme Court ruling itself is likely to have little impact on Colorado's public accommodation law, which bars discrimination according to legal experts. But Republican lawmakers were quick to attack the panel in the wake of the ruling. The Colorado Senate President Kevin Gantrum from Cannon City, saying the Civil Rights Commission should be depoliticized and de-radicalized and returned to its original mission. Now, in looking at the 2012, this is a 2012 same-sex partner, Charles Craig and Dave Mullins asked Phillips to make a cake to celebrate their marriage. Phillips refused, citing his religious beliefs. So my question is, are you that upset that the court stayed focused on what was before them? It was 2012, okay? Same-sex marriage was not legal at that time. And the case stemmed on how the court felt that Phillips was treated by the Colorado Civil Rights Commission in general. So I'm not as upset in the court ruling. I'm okay with the court ruling, and I think the court ruling moves the ball forward. All right? I think it's now time for states to step up. And it's time for us to step up and put some more things before the Supreme Court so we can take this mansion down one door jam at a time. I'm going to take a brief break. We're going to come back. We're going to stay on this a minute. We're going to talk about Bill Clinton today and his Me Too moment. We're going to also talk about North Korea, the summit. We're going to talk about, a little more on this subject here. And Clinton and his Me Too. The Eagles are not going to Washington, D.C. We're going to talk about that when we return. And governor's race has something to do with this. I don't know. And maybe you should stay away from Disney World this month because I don't know what day is Gay Pride Day in Disney World. Just saying. Take us a break, Amanda.